Good afternoon, everyone, and welcome to the Paul M. Van Arsdell Jr. Memorial Lecture on Litigation and the Legal Profession. My name is Vic Amar. I have the honor and pleasure of being the Dean here at the College of Law, and my role here today is a narrow one, but important in the sense that we have a wonderful speaker that I'd like to tell you a little bit about. First, though, a little bit about the person who's responsible for this lecture series. A triple Illini, that is someone with 3 degrees from the University of Illinois. Paul Van Arsdell was a partner at Latham & Watkins in Chicago. An outstanding litigator in consumer law, he was regarded by his colleagues as an incredibly hardworking attorney and also, perhaps equally importantly, a mentor to junior attorneys in his footsteps. He became the youngest head of the firm's finance committee, and for those of you who go on to law firms, you'll realize that the finance committee is a committee that they pick only people they trust for, because that's the future of the firm depends on maintaining good finances. And I think his selection at such a young age was a demonstration of the firm's respect for him and his work. Senator Rose, nice to see you. The firm of Latham & Watkins and the Van Arsdell family and his many friends, colleagues, and clients endowed this memorial lecture series to promote thoughtful discussion on litigation, dispute resolution systems, and the maintenance of ethical standards within the legal and government professions. So today we are delighted to welcome Richard Painter back to the College of Law to deliver this year's Paul Van Arsdell Jr. Memorial Lecture. Professor Painter has been the S. Walter Ritchie Professor of Corporate Law at the University of Minnesota Law School since 2007. Prior to his appointment at Minnesota, he was a tenured member of the faculty at the University of Oregon, and most importantly, here at the University of Illinois College of Law, where he was the Guy Raymond and Milford Van Voorhis Jones Professor of Law from 2002 to 2005. So it's our great honor to welcome him back to the College of Law and to Champaign-Urbana. Professor Painter's father, William H. Painter, was also a distinguished member of this law faculty from 1972 to 1987, and his portrait is displayed alongside other distinguished emeritus faculty here in the law school building. Richard received his bachelor's degree summa cum laude in history from Harvard and his JD from Yale Law School, where he was an editor of the Yale Journal on Regulation. Richard was actually a year or two ahead of me in law school, and although I did not know him well there, one of the rewarding aspects of being a dean is it gives you the opportunity to reconnect with people you knew at earlier points in your life and to see all the interesting and incredibly important things that they're doing. And certainly that's true of Richard. Following law school, he clerked for Judge John Noonan of the United States Court of Appeals for the Ninth Circuit in San Francisco, a former faculty member at UC Berkeley. John Noonan is a very towering figure in the Ninth Circuit. And he then later practiced at Sullivan Cromwell in New York and at Finn Dixon and Hurling in Stamford, Connecticut. From February 2005 to July 2007, he was an associate counsel to the president during the George W. Bush administration in the White House counsel's office, serving as the chief ethics lawyer for the president, along with serving White House employees and senior nominees to Senate-confirmed positions in the executive branch. He's a member of the American Law Institute, the ALI, and is a reporter for the ALI Principles of Government Ethics Project. He's been active in the professional responsibility section of the ABA. He's a board member and a vice chair of Citizens for Responsibility and Ethics in Washington, as well as a founding board member of Take Back Our Republic, a campaign finance reform organization. He's also been active in law reform efforts aimed at deterring securities fraud and improving the ethics of corporate managers and lawyers. In this regard, it's worth noting that a key provision of the 2002 Sarbanes-Oxley Act requiring the Securities and Exchange Commission to issue rules of professional responsibility for securities lawyers was based on earlier proposals Professor Painter made in law review articles and to the ABA and the SEC. Professor Painter has provided invited testimony multiple times before committees of the United States House of Representatives and or the U.S. Senate on government ethics, securities litigation, and the role of attorneys in corporate governance. Probably the best part of being a tenured law professor is the independence that it gives you to speak out, to call things as you see them, in a way that practicing lawyers who have current and prospective clients to think about, and even lower court judges who operate within relatively narrow confines of what the higher courts above them have said, cannot. I'm very proud that Richard has taken full advantage of the independence that being a professor has to really speak the truth as he sees it, and has demonstrated that throughout his academic career on contentious yet vitally important questions of democratic governance. His book, Getting the Government America Deserves, How Ethics Reform Can Make a Difference, was published by Oxford University Press in 2009. His co-authored book with Professor Claire Hale, Better Bankers, Better Banks, Promoting Good Business Through Contractual Commitment, was published by University of Chicago Press in 2015. From 2014 to 15, he was a residential fellow at Harvard's Safra Center for Ethics, which funded his work on a third book, Taxation Only with Representation, The Conservative Conscience and Campaign Finance Reform, which came out 2 years ago. He's written many, many law review articles and essays, but importantly has also spent much time educating people outside the academy by penning op-eds on government ethics for various publications, including New York Times, Washington Post, Los Angeles Times. Relatedly, he's been quoted countless times by national news organizations and has appeared on a variety of prominent television and radio programs focused on government and corporate ethics. If you watch C-SPAN and CNN and other news shows, you can't help but see Richard from time to time, which always makes me proud. So please join me in welcoming him back to the College of Law for his talk today.
Thank you, Dean Amar. I'm thrilled to be back here in the room where I used to teach a business associations class when I came to the faculty here in 1998. But my connection to this law school goes back to 1972 when I was only 11 years old and moved here. My father took a professorship here at the College of Law, and I still remember this building. It didn't look the same. There was an open courtyard where there's now an enclosed pavilion, and they would have cookouts for the incoming law students. I still remember coming down to the cookout and wanting to get an extra ice cream. It was a wonderful, wonderful law school. Then my father loved his work here. I remember back in 1972 when I arrived, and then 1973, all the exciting things going on. I remember Dan Walker, the governor of Illinois, and the much more respectable John Cribbett, the dean of the University of Illinois College of Law. And I remember in 1973 to 74 sitting at home in Urbana watching the Watergate hearings and asking my father what had happened to Archie Cox. Archie Cox, he was fired. Well, what was he doing when he was fired? Well, he was investigating the president. Who fired him? The president. There were some complications there as to how exactly it was done. I knew something was wrong. Sort of like the kids down at the elementary school firing the principal. Well, and I remember watching those hearings. Peter Rodino over in the House, and Sam Ervin over in the Senate, chairing the committees. I remember over in the House side, Liz Holtzman, a prosecutor from New York, went back to being a prosecutor after she left Congress, one of the few women in Congress at the time, asking questions. And I certainly remember Father Robert Drinan, the former dean of the Boston College Law School, who my father had gotten to know when he started his teaching career at Villanova as one of the very few non-Catholics in Catholic law teaching at the time. That was, for him, an interesting experience. And Father Drinan was a great man who always wanted to reach out to people different than himself. And he became a congressman. And he served on the Watergate Committee. And he was asking some very, very tough questions. So many questions that people didn't want him there. For some reason, the Pope told him he had to give it up. No, couldn't serve in Congress and be in the clergy at the same time. But Congress was doing its job back then. Congress was doing its job. And people said, well, President Nixon was enormously popular. He won in a landslide in 1972. Yes, with a little bit of assistance from Watergate burglars, but yeah, no Russians. In a landslide. Enormously popular. You will never be able to impeach and remove the President of the United States, much less the Vice President. Well, they investigated anyway. And by the time they were finished, the President and the Vice President were gone. The Vice President left first, Spiro Agnew, in a bribery scandal up in Maryland. They bothered to investigate. It wasn't about politics. There was some politics going on. I still remember some of the Republicans were more eager to ask questions than some of the others. There was a senator from New Hampshire named Sandman, I think, who was sort of sitting there growling all the time, and he lost his seat 2 years later. But they did their job. That was my early exposure to ethics in government. And, of course, the role of lawyers. The lawyers working for the committees, the House and Senate Judiciary Committee. I met one of them who came off, I believe, the Senate Judiciary Committee, a young man named Ronald Rotunda. He came off the Watergate investigation. I came here to the College of Law to teach. I remember meeting him in the 70s. This is long before, he always had the bow tie, but this is long before Ron had the Rolls Royce that he'd park right over here. That was after he published a few case books and got some royalties. But he was an expert on constitutional law who had learned a lot from the Watergate Committee before he came to the faculty here at the College of Law. He just passed away very recently. But there were many great lawyers, not only Archie Cox, who of course was fired, but then replaced very quickly by Leon Jaworski, who turned out to be a very talented prosecutor and got down to business very quickly, much to the chagrin of President Nixon and his cohorts. Well, I went into law myself and went into law teaching and eventually came back to the College of Law. Here in 1998, I taught business associations. I taught business associations in this room, and I remember cold calling on one Chapin Rose, who is now a state senator, one of my favorite students. He was, I think, in the seat a little bit further over there. Chapin knew his stuff. Yes. Yeah, still in the back row. Well, yeah, the back row kind of guy, but he knew his stuff. Now, there were always some people I called on, and they didn't know their stuff, and I'd say, well, you must have had a late night at the office. The office, I don't know if it's still open. It was a bar over in Urbana. But most everyone was prepared. I also taught professional responsibility and lawyers' ethics. I didn't do a lot of work on government ethics, except for the role of lawyers in representing government agencies and the role of lawyers in the Justice Department. I taught that in my ethics class here. And we had some old selections from the Nixon times when President Nixon tried to hotwire a case that had been brought against ITT. And, well, they were campaign contributors, so we ought to sort of drop the antitrust case. And there was some back and forth on that. And the Attorney General was called to testify in front of Congress, and he lied. That was Attorney General Richard Kleindienst. That's not a good idea. Lying to Congress, not a good idea. I hope my students at least got that point. You know, of course, the Watergate era was what we looked back into for, you know, what could go wrong. And that is when professional responsibility started to be taught in American law schools, was the years after Watergate. We realized we had had a lawyer who was a president who had actually been second in his class at Duke Law School. There was nothing deficient about Richard Nixon when it came to his intelligence or his work ethic. But the ethics were somewhat lacking. And the idea that you could be the best lawyer around, the most successful, you could become president of the United States or head of a major firm in New York or Chicago, but ethics matters. And that's where we started teaching ethics in the law schools. And Ron Rotunda became a co-author of one casebook on ethics, and I had another casebook with Judge John T. Noonan, and ethics for lawyers was taken seriously. I then went to the White House in 2005 to become the ethics lawyer for the president. And the White House staff and those appointed to executive branch positions. And it's there that I was first exposed to some of the issues, the very troubling issues that I want to discuss with you today. Because some of what we are seeing now under the Trump administration is new, and some of it isn't. Some of it is just more of the same. And a lot of it is making voters very upset, very alienated from our democratic system. Voters who support both parties or neither party. This is not a partisan issue. What's going on in government, there should not be a partisan issue. But we are, I believe, moving in the wrong direction. And that is not just because of the leadership we now have in the White House. We've been moving in the wrong direction for quite some time. I think we were going in the right direction in the years after Watergate, but things have been deteriorating in a range of different areas, and I'm going to talk about some of them. Well, let's start with that provision of the Constitution that has led me to complain endlessly about President Trump and even to bring a lawsuit against him in the Southern District of New York, not personally, but in my capacity as Vice Chair of Citizens for Responsibility and Ethics in Washington. This provision of the Constitution is there to address or to prevent some of the most dangerous conflicts of interest for United States government officials in the view of the founders when they drafted the Constitution. It is the emoluments clause, which specifically prohibits a person who holds a position of profit or trust with the United States government from accepting from a foreign government any title, any present, any emolument. And it's any of these things, any emolument, without the consent of Congress. So if you serve in the United States government, you may not receive a gift from a foreign government, you can't receive a title from a foreign government or an office from a foreign government, and you cannot receive an emolument. Well, what is an emolument? Well, the dictionaries at the time, most of them, including Dr. Samuel Johnson's dictionary, said an emolument is a profit or benefit. Any profit or benefit you get from a foreign government. And you would think this would include entities controlled by a foreign government. If a foreign government cannot give you a present or a profit or benefit, that foreign government shouldn't be able to use an entity it controls, whether it be the Bank of China or a sovereign wealth fund, whatever it is, to give you this profit or benefit. I learned about the emoluments clause when I was at the White House, because before I go to the White House, when I was here at the College of Law, every summer I'd go off to Germany and give lectures at Bielefeld University. And I'd been invited over there by a professor who used to be an LLM student here at the University of Illinois College of Law many years ago. And my wife did a lot of work on music history, and she's now a professor at the University of Minnesota. She did a lot of research over there. So we'd like to go to Germany, and Bielefeld University would give me $2,000 to pay for, I'd have to pay for my own airfare and pay to rent a flat. But it worked out. We could make it work out. And go over to Germany, and I'd give some lectures on corporate law and securities law and mergers and acquisitions and all those things, and then go have beer with the German students afterwards. The German government did not pay for my beer, but they give me the $2,000 to pay for all the expenses. Well, the problem is, yes, the University of Bielefeld is a state university. It's controlled by the German government. So I said, well, when I was at the White House, if I wanted to do this during a 2-week vacation or 1 week, a shorter vacation, obviously, when you're working there trying to keep the Bush administration people ethical, I can't have the ethics lawyer off too much for the time, but maybe a week or two. Well, no, can't take it. Why? Well, there is State Department guidance on this. You cannot take any of these speaking engagements with state universities outside the United States where they pay even your expenses. That might be an emolument. They're very strictly enforcing the emoluments clause. Now, why do we have this clause? Is this some arcane provision of the Constitution that we don't need? No, the founders weren't stupid when it comes to conflicts of interest. They knew that there was no point in winning the American Revolution in throwing all that tea into Boston Harbor. I'm talking about the real Tea Party, not the make-believe things we got going on today, but the real deal, where they put the tea into Boston Harbor, and they had the revolution. Many Americans died, and or we're going to have our own country. What's the point of all that if you're going to have a president or a secretary of state who's buying and selling tea with King George? Not going to work very well. And then what was going on in Europe at the time? You look at the speeches of Edmund Burke on the floor of the House of Commons, and he was complaining about these various emoluments that members of the Parliament were getting. Some of them they were getting from the British Crown. British king wanted to bribe members of Parliament with special favors and deals and offices and presents. But the King of England, King of Great Britain, had a competitor, the King of France, who was also bribing the British Parliament. King of France didn't have a parliament to worry about. That's one of the problems he had. Caused some difficulty. He lost his head a little while later. But he was busy bribing the parliament in the United Kingdom, the King of France, and the other big, powerful European empires were playing the same game. Austria-Hungary. They were putting all sorts of money and special deals around to try and keep all sorts of princes happy inside the Austro-Hungarian Empire and outside. So there are three of the great superpowers of the 1700s, of the 18th century: Great Britain, France, Austria-Hungary. There's a fourth big superpower then, too: Russia. Yeah, they were busy doing that. It was Polish and Lithuanian princes and various people in the Balkans, but the czars were paying people off, influencing what's going on in other countries. It's an old Russian game, all right? The founders understood this problem, and that's why they had the emoluments clause. This is to prevent any type of financial dependency of an American government official on any foreign government. They were very worried about this problem of someone who's beholden to a foreign government coming over here and getting involved in our government. They were so worried about it, they also put another provision in the Constitution. President Trump likes this one. It says that the President of the United States must be a natural-born citizen. Yeah, that's why it's in there. They were worried that some probably British guy, would get a bunch of money, come over here as a rich merchant, set up shop in Boston or someplace, and then buy his way into politics, become president, and say, hey, we want to be a colony again. Said, we're not going to take that risk. The President of the United States must be a natural-born citizen, born inside the United States, as President Obama was born inside the United States. But that part President Trump has never figured out. Alternative facts, I'll get to that theme a little later. But, the founders were very scared of this problem, and that's why it's there. Now, how do you enforce the emoluments clause? Oh, now we got a bit of a problem. How do you enforce it? Now, one strategy is litigation. But litigation requires a plaintiff. And as you learn in civil procedure, plaintiffs must have standing. Now, I believed, and Larry Tribe at the Harvard Law School, who worked with us on these briefs, Norman Eisen and others, we believe very strongly that Citizens for Responsibility and Ethics in Washington, our organization, under the case law in the Second Circuit in New York, would have standing because of our focus on ethics issues in government, our unique focus there. Well, Federal District Judge Daniels disagreed with us and threw our suit out, so we appealed to the Second Circuit. But maybe that makes a big difference, maybe it doesn't, because the substance of our complaint is that President Trump is receiving profits and benefits from dealings with foreign governments, including the Trump Hotel, when foreign officials come and stay at the hotel, and foreign governments book the ballrooms at the hotel. And then there's other issues about whether there's any foreign government money in the Trump organization. I don't know whether there is. Bob Mueller may have some suspicions. And I don't know what countries might want to fund the Trump Organization or who might not. We just don't have the information because we don't have the tax returns. It's not a public company. Well, what we do know is that around 1993, when I left New York to go into law teaching, that nobody in New York wanted to loan any more money to the Trump Organization because of $900 million worth of defaulted casino bonds. And people usually don't like to throw more money at that type of situation. So I don't know where the president's been borrowing his money. So I don't know whether there is a mega emoluments clause issue because we don't have the information. And that's one of the things we would seek to get in this lawsuit. Now, ours was thrown out on standing. We're going to appeal that. But there's another lawsuit brought by the Attorney General of the state of Maryland that is basically a markup of our complaint on the merits. But the Attorney General of the state of Maryland says, well, we get to go in along with the Attorney General of the District of Columbia because this hotel competes with our businesses. And they have an unfair advantage because of the unconstitutional emoluments they're receiving. That suit did survive the motion to dismiss. Not only that, but the federal judge in Maryland then interpreted the emoluments clause. And the federal judge in Maryland said that the emoluments clause means pretty much what I just told you it means. And so he cited, there's a paper, if you want to look into this in more detail, on the Brookings Institute website by myself that I co-authored with Larry Tribe, the constitutional law professor at Harvard, and Norman Eisen, who's the former chief ethics lawyer for President Obama. And our paper on the emoluments clause and its context and meaning and how it applies to President Trump. They're on the Brookings Institute website. You don't need SSRN or anything to download it. And the judge did agree with our theory, as opposed to that being advanced by the Justice Department, using our taxpayer dollars, arguing for President Trump, that emoluments only means payments in connection with his office of being president, I guess, or maybe two-timing or something, holding an office in two countries. I didn't really figure out what their argument didn't make any sense, but they made it anyway. Well, the federal judge rejected the Justice Department's argument and accepted ours. So that case is going to proceed. And there's yet a third case under the emoluments clause brought by Democrats in the House and Senate who say, well, the emoluments clause says that you cannot take the emolument without the consent of Congress. So you never came to me and got consent. So they brought another case, and that one's down in the District of Columbia. Okay, so the one way to enforce the emoluments clause is through the courts, but you need a plaintiff with standing and the judge willing to rule, and we're going to see how that works. Now, Judge Daniels, when he dismissed our case, one of the things he said is Congress ought to enforce it. He said Congress is not a potted plant. Well, I think this Congress is acting like a potted plant. Now, maybe, we as voters, we can go and, take the pot and do a little of this and see if we get anything better. I don't know whether we will or not. But Congress needs the will to do its job. And that gets me back to the Congress that I watched on television, sitting there at home as a kid in Urbana back in 1973 and 74 when they actually had hearings. But Congress needs the will to do its job. And that's not what we're getting right now. So we have yet to see what will happen with the emoluments clause. I have suggested by way of a reform here that we ought to pass a statute that gives the Department of Justice the authority and a mandate to bring a criminal suit if there is a criminal action against anyone who's a government official who is accepting unconstitutional emoluments in excess of a certain amount, $50,000 or some fairly substantial amount. So the DOJ would be not only empowered but obligated to open an investigation when there were very large emoluments at stake. But we do not have that at this point. The receipt of the unconstitutional emoluments is not a criminal violation, no matter how large they may be. Now let me turn briefly to another problem, which is other financial conflicts of interest other than foreign governments. This is a very old problem. I've written about it. It happened in 1720 in Great Britain, the South Sea Company, which was like Enron. It went down in flames, complete collapse. Well, who were the shareholders? A bunch of members of Parliament, and even the King's mistress. I think the Queen had been shut out of the action. But I mean, they were all in it, and the members of and the people in the Exchequer, the whole government was trading in South Sea Company stock. I'm sure sold at the high point. And then the whole thing collapsed, and then Parliament said, oh, we got to have a great big investigation. What, of ourselves? Right. Nothing happened. It's an old problem. The founders never realized that they had their own conflicts of interest when they founded this country, because many of the founders owned very large agricultural establishments that had slave labor. We're reminded of this by President Trump, who said, well, President can't have a financial conflict of interest. President Washington went back to visit Mount Vernon, and President Jefferson kept Monticello. So I'm no different than they are. Well, there are many great things about President Washington and President Jefferson, but I don't think the slaveholding plantations were part of what was good. And the fact that many members of Congress also had slave labor, the very large plantations. So they're financially dependent upon a legal regime which had been in the British Empire. The slave trade had been abolished, and Great Britain was shutting down slavery in that process of doing that while we were expanding slavery. So conflicts of interest, financial conflicts of interest, have consequences. And indeed, one of the most tragic parts of our history it has its root not just in racism, but in financial conflicts of interest of our founders, those who drafted the Constitution. Now, where are we today? Today, we have a criminal statute, 18 United States Code 208, which applies to every single executive branch employee other than the president and the vice president. This provision makes it a crime to participate in any United States government matter that has a direct and predictable effect on your own financial position. So if you own stock in an energy company and you go to the Department of Energy and make decisions about regulating oil companies, you may commit a crime. I told Hank Paulson when he came into the Bush administration to become Treasury Secretary that he would have to sell his Goldman Sachs stock. I said, well, Mr. Paulson, how much Goldman Sachs stock do you owe? Oh, about $600 billion. I felt very sorry for him. But you got to sell it. And we arranged to sell it. We even arranged for him to get a deferment on capital gains tax. Yeah, you can do that if the ethics lawyer tells you to sell it. There's a special little provision in there. So he wasn't too unhappy. But he had to sell the Goldman Sachs stock because it is a crime to do anything in the executive branch as an employee, whether you're the janitor in the Pentagon or the Treasury Secretary, that has a direct and predictable effect on your financial holdings. I had a lot of people sell a lot of stock because they don't want to go to jail. But that statute doesn't apply to who? President, Vice President, or members of Congress. Congress is very good at passing laws that don't apply to themselves. So that's where we are now in 18 United States Code 208. Well, what has happened is over the years, most presidents have avoided financial conflicts of interest. Most all vice presidents have. There was a few wrinkles with respect to Vice President Richard Cheney and Halliburton that I won't bore you with, other than to say that Vice President Cheney never sought my legal advice, and they made it very clear that my advice was not welcome in the vice president's office. So there was a little wrinkle there, but I don't think it was anywhere near as egregious as some of the other things I'm going to talk about. And then, of course, things suddenly changed with President Trump. And he says, well, the president can't have a conflict of interest. So this is an area where norms matter. Even if it is legal, doesn't mean it's right. And we developed norms. Richard McAdams, who's a colleague of mine here at the University of Illinois and then went up to Chicago, wrote a lot of articles, law review articles, on norms in the law and how important norms are. What we think is right, the right way of doing things, and that norms can be enforced not through legal means, but politically and in other ways. And, the norm was that presidents would try to, and did, avoid financial conflicts of interest. Members of Congress, most of them. But we had our exceptions. Senator Bill Frist owned a large healthcare company while he was talking about how we needed to make sure not to regulate healthcare companies. He was a senator from Tennessee. I just finished a race. I lost a race. I ran in a primary for the United States Senate against Senator Tina Smith of Minnesota. I did point out I do want her to sell her for, she's got a couple $1 million worth of medical device stock. They ought to sell it before you start making decisions about health care. So they're members of Congress who have these financial conflicts. They're illegal because they're not covered by 18 United States Code 208, but they're going to make it awfully hard for Congress to go after President Trump. Once again, the consequences of conflicts can be dire. I mean, healthcare is one of them, because healthcare costs are skyrocketing, and we need to get the cost of drugs and medical devices and all that under control. We can argue about the solutions, but the people passing the legislation probably shouldn't personally have investments in those areas. Foreign relations. When you have government officials who have investments in foreign countries, even if they're not getting money from foreign governments in violation of the Emoluments Clause, there's a serious national security risk. I remember hearing from my grandfather about a movement called America First during the 1940s, where a bunch of businessmen in New York did not want the United States to go in against Germany in the Second World War. A lot of those businessmen had a lot of money invested in Germany. They dumped a lot in. John Foster Dulles, the head partner of Sullivan and Cromwell, had a whole bunch of clients over there in Germany. A lot of America Firsters. My granddad was on the other side. He wanted us to get in there and kick Germany in the behind. So it was all fighting with America Firsters. That's a serious conflict of interest. But those people in the private sector, what if Franklin Delano Roosevelt, a rich man from New York, yes, he is very rich. He had a Roosevelt Tower in Berlin, another one in Hamburg, and a third one, in Frankfurt. That wouldn't have been a good situation. And so when we have a president invested in foreign countries that have some issues with democracy and maybe moving in the wrong direction, that is a very dangerous situation. And one of my concerns with President Trump is does not have a lot of investments in places like Western Europe, Japan, established democracies. He, for one reason or another, seems to favor countries that are 50-50 or completely authoritarian regimes. And that's not a good situation for our national security. Conflicts of interest have consequences. I think what we ought to do here, by way of solution, is to apply the statute, 18 United States Code 208, to the President, the Vice President, and the members of Congress. I know there's a constitutional issue, and they would argue that it's unconstitutional to apply it to them if they were actually prosecuted. But I think if you simply included them in the statute, at least the court of public opinion would say that's wrong. You can't do that. And I'm not sure the constitutional arguments against including the President, the Vice President, and the members of Congress in 18 United States Code 208 are particularly valid. Happy to explore that later in discussion. We have many other problems in government today. I don't have time to go through all of them. Use of public office for private gain. Whether it's the president promoting his golf courses or Kellyanne Conway shilling for Ivanka's clothing, which is now, I think that clothing line's been shut down, but on Fox and Friends. I mean, that's the small stuff. The bigger stuff is we have, of course, the cost of the trips down to Mar-a-Lago and then the trademarks all over the world. And really even bigger stuff that bothers me is when you have the president's sons traveling the world cutting deals. And for a while they had the Secret Service in tow. And the problem is you're going to a lot of countries where pay-to-play is sort of the norm, as, well, it is here too. We just do it a little differently through campaign contributions. I'll get to that. The impression is, you cut a good deal with a Trump organization and things will be pretty good for you. People are getting that message. And then you have the Kushner family with this business going on with the EB-5 visas over in China, where they were letting people know, well, if you invest in the United States, you can get a special visa, which is true. Invest in any American business, $500,000 or something, you get a special visa to come to the United States and live here. But the impression was if you invest in a Kushner business, well, you just might get a little priority. And this was not being pitched by Jared Kushner himself, but members of his family. So you have a whole bunch of these situations where there appears to be use of public office for private gain. Now, I'd have to say once again that existing law can deal with some of it. For example, Kellyanne Conway should not have been shilling for Ivanka clothes on Fox and Friends in an official interview. But the White House counsel's office, I don't know if they have an ethics lawyer right now. The ethics lawyer, in response to that instance, wrote the head of the Office of Government Ethics and said, the government ethics rules you're talking about don't apply to the White House staff, which is news to me because I always told the White House staff that all the government ethics rules apply to them. And I think that's the right result. But once again, a lot of this is about norms. What kind of norms are we willing to enforce in government? And, another problem is quid pro quo, the bribery problem. Now, this is an ancient one. It goes back 2,000 years. It's traced by Judge John T. Noonan, my co-author in my professional responsibility case book. He wrote a book called Bribes, The History of Bribes. Yes, a federal judge who wrote a book on the history of bribes. Yes, but he was on the good side. Judge Noonan saw this as a moral evil, but a very difficult one to combat. Because bribery, you need to prove the intent, particularly if you prosecute it as a crime. Very difficult to prove. And that's why we have the emoluments clause. That's why the founders said, well, when the foreign governments are involved, let's just say no money changes hands, because that's just too risky. But in all these other situations, bribery is hard to prove. And guess what? The United States Supreme Court has made it even harder to prove in a case brought against the former governor of Virginia, McDonnell. And he was prosecuted for bribery under the mail fraud statute. But basically, it's a violation of the bribery statute. And the Supreme Court said, well, the exchange of access to a government official for money isn't a bribe. You have to actually agree to do something specific in government in return for the money in order for it to be a bribe, not just access. So that's why not only did Governor McDonnell get off the hook, but those jury instructions in the trial of Senator Menendez of New Jersey had to include that recent Supreme Court ruling. And Senator Menendez got a pass. Many of us disagree with what the Supreme Court did there. And if the court had gone the other way, Senator Menendez, well, he wouldn't be running again, I'll put it to you that way. Bribery is very difficult to prove, particularly under the current law. And we can think about changing the law and making maybe a lesser crime to exchange access for money. So there are things we can do on this. But this is a problem that is an ancient one, and we shouldn't just point to the problems in the Trump organization and what we see today. Now that gets me to my final concern, campaign finance. I mean, at the end of the day, whether it's quid pro quo, which amounts to bribery, almost impossible to prove under existing law, or near bribery, or however you want to describe it, our campaign finance system is a disaster. That's the topic of the book I wrote when I was at Harvard. It's called the book on taxation only with representation, explaining why political conservatives should support campaign finance reform. And indeed, the polling data shows that ordinary voters, grassroots voters, conservative, liberal, moderate, are all disgusted with the campaign finance system. It's only higher ups among the elected officials where you get this divergence of opinion. Indeed, that is how President Trump, he won the primary. He was one of the first Republican candidates to call out the campaign finance system. He said, you guys are all bought. He was right. Rather than being bought, he wanted to buy everything. Well, whatever. But, he had a point. And people flocked to Trump because of that. So we need to fix campaign finance. We need more disclosure of the money coming in and out of our political campaigns. We need more small dollar donors. And that's why in my book I suggested that we ought to have a tax credit. For the first $200, your taxes goes to a campaign of your choice. We have a system similar to that in Minnesota with the first $50. I think that would actually save money in the federal budget because you at least have some members of Congress who aren't dependent on big defense contractors or whoever it is who wants to milk off the federal government for the big contracts, that some members of Congress might be more dependent on small dollar donors. So bringing in the small dollar donors. And last, getting the Supreme Court out of the business of striking down campaign finance regulation. They don't understand it. They don't understand what's really going on. They keep saying, well, it's not a problem unless there is a demonstrable quid pro quo, in other words, a bribe. Anybody who's been involved in campaigns knows what goes on. I just ran a campaign. I wouldn't take any PAC money because of what I know goes on PAC with PAC money, but most of them do. And those PACs aren't there to, because they agree with your ideology. They want one or two things. That's what they want. And they make that clear when they give you the donation. That's why I wouldn't take the PAC money. So we got to address this problem. The members of the Supreme Court don't understand it. And this is not just Citizens United. This goes back to Buckley versus Vallejo. In 1980, early 80s. And Barry Goldwater, of all people, said the Supreme Court should butt out and not be striking down campaign finance laws. And the corporate money and union money has no legitimate role in politics. It should be individuals in making the contributions. So this is not an ideological issue, or shouldn't have been. We need to address campaign finance. And the last thing I want to say, I want to have some time for some questions here and answer, well, what I can give you by way of answers, is we need to get back to focusing on the value of law, the rule of law, which means respecting law as having some value, inherent value in our society, and also respecting the importance of facts, real facts, not alternative facts, as Kellyanne Conway said, real facts. And I'd say that, unfortunately, we've had a deterioration of respect for law and the inherent values in law, moral values in law, and also respect for facts, real facts. And this is a problem that goes back a long time. My colleague here at the University of Illinois, Matthew Finken, wrote a great book review in the Minnesota Law Review called Quatsch, which is German for BS or garbage. He was describing some of the theories that were first espoused in the 1930s by a German jurisprudent named Carl Schmitt, who was talking about how a law really just reflects political power and doesn't reflect a sense of right and wrong. It's just about political power and one group of people trying to oppress another. In other words, everyone else trying to oppress Germany. And that law is relative. The values are relative. There's no absolute truth. And the same with respect to facts. We can all view facts differently because we all have our own alternative sets of facts. And these were the ideas being espoused in the 1930s in Germany. We see where it went. We saw a resurgence of some of this on the political left in the 1990s in the United States in legal academia. And that was what I think Matt was criticizing in that article in the Minnesota Law Review, in that book review. But that never got any further than academia. Never really got into the White House or anywhere in positions of power. You'd have academic arguments about there's got to be something that's absolutely morally wrong. For example, torture is morally wrong, isn't it? And then some of these critical theory people would say, well, not necessarily, but they never got in the White House. Who did? Who got in the Justice Department? John Yoo from the Berkeley faculty, law professor. He wasn't a leftist at all, but he used the same approach. He read that torture memo. The law is distorted. It's like, well, we can see law differently through different views. Well, he distorts the law and the facts of what was actually going on. He assumes facts with respect to the interrogation of detainees that just simply weren't true, alternative facts. So this is now, once again, this moral relativism, this refusal to accept absolute truth, right and wrong, and to also acknowledge facts as facts is a powerful weapon in the hands of the political right. Not yet as dangerous a situation as evolved in Germany in the 1930s, but as I've said, I think far too many similarities. We have attacks on the press, attacks on religious minorities, attacks on judges, attacks on prosecutors. So we need to get out of the world of alternative facts and alternative law. Of course, law changes to reflect evolving social norms. Facts, we may uncover new facts that make us change our opinion. But facts are facts. And this has been a serious concern quite recently. Because when I was in the White House, we used to say, it's the Washington Post test. How would this look? It may be legal, but how would it look in the Washington Post? Today, it may be the Fox News test. Well, it may be legal, it may be illegal, but the really important thing is, can it be adequately defended by Tucker Carlson or someone else on Fox News? And once every couple of months, Tucker invites me on the show, and we have some fun. But we need to get back to the rule of law, and law, describing the law for what it is, not what we think it is or what our own political perspective says it should be, and facts as facts. I want to thank you. I want to take some questions.